Thank you very much for coming for us this afternoon, producing a voluminous report. I'd like to begin, we've got quite a bit to get through, as you'd expect with a 500-page report. I'd like to begin by asking you, Lord Turner, a question. You saw that Sir David Walker said your original decision to publish a one-page document was driven by a desire to say no more than you absolutely had to. Isn't that a reflection of just how cut off the FSA had become, and indeed has become?
I think I entirely accept that what we, and I personally, failed to focus on at the time was that it is important when something has gone wrong that there is a public account of it. I think we stuck too narrowly to our existing procedures. In fact, we went a little bit beyond them, because our normal procedure when we decide not to bring an enforcement action is we don't actually say anything. So even putting out a one-pager was a deliberate decision that this was sufficiently important that we ought to say something. But I think I wish that back in 2009 I, or other people might have suggested it, had realised that the failure of RBS was such a big thing that we should have a public accountability report. So that's what I now believe.
Why did you put out a one-page note?
Well, as I say, our normal procedure, when the enforcement division decide not to bring an enforcement action, is not to put out anything. I mean, obviously, at any one time, month by month, there may be many situations.
You scarcely could have thought that a one-page note was much of an improvement, Lord Turner.
Well, we felt that we had to comment on the fact, given that people had speculated that there was almost certainly something going on in an enforcement investigation into RBS. We felt that we had to say that it had reached conclusions. But I entirely accept that we were sticking to the existing procedures and not being imaginative enough in realising that this would require a wider accountability, and that was a mistake.
David Ruffley.
Mr. Sants, the criteria for assessing whether individuals had acted in a way which could lead to formal disciplinary action rested on whether it could be demonstrated that they had acted in a dishonest, reckless or incompetent way. Can you point to the page in the report where incompetence is defined?
Well, I think that the decision as to whether we should take enforcement action rests on the recommendation of the Enforcement Department, which in itself is a separate process accountable through the RDC to the board. So if you don't mind, I think it actually would be better if Margaret could answer the question.
No, I wouldn't be happy with that, because you are going to be taking a job as Chief Executive in the Prudential Regulation Authority, which is going to be the premier authority for supervising banking. There were a series of, the report says, bad decisions in the years immediately before the crisis, and I want to get to the bottom of it, and I want to hear your view on how incompetence is defined in this report.
Well, as
it's not, is it?
Incompetence per se is not defined in the report. What we would be having to demonstrate is a breach of our regulatory rules, and as the enforcement section of the report lays out, the Enforcement Department found that there was no basis to proceed on that against that framework. The Executive Committee certainly listened to and challenged and engaged with the Enforcement Department to satisfy itself that that conclusion was thoughtfully reached, and I believe it to be.
Okay.
But to your point, absolutely, there is not. We would have had to have demonstrated a failure to comply with the FSA's procedures and rules and framework in order to have taken an action.
Yeah, but you see, what most people, I think, are amazed at in this report is that there are no serious sanctions against significant individuals, with the exception of Johnny Cameron. Fred Goodwin emerges relatively unscathed, and I just want to pursue this question of what you think competence and incompetence is in the case of the RBS debacle. The report says the substance of decision-making by the board in relation to ABN AMRO was defective at the time, whatever the subsequent deterioration in the market and wider financial environment. Now, wouldn't you agree that making a decision as significant as the ABN AMRO acquisition, and even with without the benefit of hindsight, was judged to be poor? Doesn't that imply a very large degree of incompetence? And I really want to understand, and I think people listening to this will want to understand, why no one has been fingered for that in this report. It's a pretty useless report in that sense, isn't it?
Well, I entirely agree with you.
You agree with that?
The substance of the report is to make clear that we considered the board and the senior executives of RBS, which includes Goodwin, to have made a series, there was more than one, of very poor decisions which led to the bank failing. And I would also agree with you, and Adair's discussed this in his forward, but I entirely endorse his comments, that going forward we should change the regulatory regime to allow the regulator to take those sort of assessments into account to ensure that people who have showed that sort of serial misjudgments are not allowed to run financial institutions again.
Fine.
And that is absolutely my view. So I entirely support Parliament making changes to the regulatory framework so that we can stop people like it's working again without any confusion or any risk that that would not be the case.
I think that is a very useful disclosure you've made, Mr. Sants. Could I sum up your reply there as saying that the FSA did not have the enforcement powers under the FSA regime to bring Mr. Goodwin in particular to book in terms of enforcement proceedings? Is that what you're saying? You're blaming the structure of the way the FSA was set up and the powers it was given by Parliament at the end of the 1990s?
I am absolutely saying that in my judgment, my personal judgment, the set of failings demonstrated over a prolonged period, I think there's more than one here, I think you have to build a track record, just to be clear. There is a clear track record of a series of misjudgments by the executives of RBS, and in my judgment that means they are not fit to run a regulated institution.
Right.
And I would like to see the framework under which regulators operate changed so that in future, if people demonstrate that type of serial misjudgments, which demonstrates they're not competent, that we are able to take action against them.
Right. Now, in the announcement of the outcome of the enforcement regulation, the FSA said, and I quote, "The competence of RBS individuals can and will be taken into account in any future applications made by them to work at FSA-regulated firms." Isn't the implication of that you would deem some of them to be incompetent? And if some of them were incompetent, why couldn't you take enforcement action against them?
Yes to your first question. So absolutely, I should make clear, by the way, I'm giving my personal opinion because strictly...
they're very interesting.
Because strictly speaking, we are not allowed, by the rules under which we operate, to make a judgment unless somebody reapplies. So I should be quite clear that I'm speaking to the committee in a personal capacity, because as the FSA, we're not allowed to actually say, by the rules under which we're set up front, what would happen if somebody applied.
You're speaking under parliamentary...
But I am making clear that, as far as I'm concerned, if any of those individuals apply, I would not consider them to be competent on the basis of the track record demonstrated. But I did if I could draw a distinction, which again is an issue around the regulations, and I say I would be keen to allow Margaret to, I know she feels strongly about this, to also contribute to this discussion. But again, if I could just explain, the threshold for barring somebody's authorisation is lower, is less demanding than the threshold for enforcement action. So whilst I can say with confidence that these people will not work again in the regulated sector in an executive role, in my opinion, it does not automatically follow from that it means we should have been able to take enforcement action. So I'm entirely in agreement with you. In order to get the type of result that you would like to have, I think we should have, we need changes to the framework under which we operate.
Right. So could I just ask Lord Turner, I know he wants to get in, but I just want to ask my final question, Chairman. Now, the report quite clearly says that the FSA cannot, and I quote, take action against the CEO, in this case Fred Goodwin, of a firm simply on the grounds that there were a number of failures at the firm, even though the CEO is ultimately responsible for the actions of the firm, close quote. Now, don't you think that is a grotesquely inadequate system of regulation, that a man like Fred Goodwin can pretty much walk away from this mess scot-free?
Well, that is why in my forward I deliberately put on the table the fact that we need to explore whether there should be a change in the law. The point I wanted to come in on is this issue of what is competence and was there not a case for competence. I have to assure you was something which the board subcommittee which oversaw the production of this spent a long time quizzing enforcement about, and is something I've considered. I think the way the law works at the moment, and in the best judgment of our enforcement lawyers as to what they would be successful in appeal to the upper tribunal, is that the way it is interpreted at the moment, competence has to relate not to a broad set of decisions. You can't, as it were, accumulate lots of decisions and say, if 10 of them were bad, there must be some incompetence. You have to say, look, here, you didn't follow the procedures. You did that wrong. You clearly didn't have a technical competence in that very specific effect. And that, bluntly, and it is something that has worried me, may bias our enforcement activity to, as it were, zeroing in on very specific things that we can prove, even if, seen widely by most reasonable people, they may not be the most important things to what led to a failure. And that is one of the reasons why, in my forward, I raised the question as to whether we should have a different structure of law that says where something on this scale has gone wrong, there should be some category of automatic sanction which applies to the people who are responsible, whether or not we can prove that in some procedural or specific fashion they did something wrong. So that is precisely why I put those issues on the table in my forward.
Just one final one-line question, one-line answer, if you would, Lord Turner. Has the government in its new financial services bill, in your judgment, addressed the problem you have just explained and which is in your forward to this report?
Not yet. At the end of March, the FSA and the Treasury will produce a joint discussion paper on this issue, putting forward options, which is intended to be consulted on so that the government could then put it in, and my understanding their intention is, as part of the legislation which will also implement the Vickers recommendations, on which I believe a white paper may be forthcoming before the summer.
Isn't this a huge mess? We've got a piece of legislation that is amending another hugely complicated piece of legislation. And now you're telling us that with the bill now published already, that's effectively redundant, at least on this point. Because that's going to be further amended, even before we've had a chance to read it.
Given that we are in any case, because of Vickers, going to have two financial services bills, I don't think there is a huge disadvantage in that, as long as at the end of the day we have an appropriate way forward.
The measures that we're discussing here are pertinent to the
they are clearly pertinent to this.
And nothing to do, or very little to do with secondary to Vickers.
No, they are clearly pertinent to it, and if we had started on this debate a year ago, it might have been part of the pre-legislative scrutiny and gone into this bill.
And they should have been subject to pre-legislative.
But I think it would be unfortunate now to rush this. I think there are a set of very complicated pros and cons of the different approaches which I put on the table.
Well, this committee has been arguing that this legislation is being rushed for many months and has already published that view, as you know. And you're saying you support that. And if we leave this open for a few more months, we might get to a better place. That's what you're saying.
Well, I think we have a procedure now to put all the issues on the table. They're very important ones. I think the pros and cons of the different approaches need to be carefully analysed, and the next step will be this joint FSA-HNT discussion paper to actually widen the debate.
But all that's going to have to go on while the bill is actually in committee.
That is true. That is true. But
do you think that's a good way to
I don't think it's
legislate?
Really,
having just got it manifestly, seriously wrong, and you're saying we did 10 years ago, where we rushed it then.
I don't think it's really for us to comment on the parliamentary timetable and the management of the legislative process.
As close as you can to commenting on it. Jesse Norman.
Thank you, Mr. Chairman. Mr. Sants, you've spoken about the serial incompetence of members of the RBS management. And let's not forget, this was a contested, mainly cash takeover for a another institution with a value of 71 billion euros. Shortly after it, the Royal Bank raised its dividend before throwing up its hands with the loss of £40 billion. The reviewers last week, when we saw them, said that the due diligence done by Merrill Lynch in advance of the transaction, who were the advisors to the RBS, Royal Bank of Scotland, consisted of 2 lever arch files and a CD. Now, when you were in your position as Managing Director of Wholesale Institutional Markets in April 2007, can you take us through the kind of deliberations inside the FSA at that time as to whether or not you should have intervened? What were the kinds of things that you were talking about and thinking about?
I'll just make a sort of general introductory comment. I will answer your specific question, but I think just as a general point, I'd like to just say something up front on this. I can see a number of questions in this space. So I'd just like to make clear that I agree that the general approach to supervision and the policy framework that accompanied it, that was in place in the FSA before the crisis, before the summer of 2007, in relation to overseeing UK institutions, UK banks, was inadequate. And as soon as I could, once I took over as Chief Executive, I changed that.
Would it not be fair to say grossly inadequate?
Grossly inadequate. Totally unacceptable to me. And that is why, as soon as I could, I waited for the Northern Rock report, which I think was right and proper, but I would effectively made many of those changes anyway. And from March 2008, as you know, we embarked on a radical change to the entire approach to supervision and a wholesale change to the people involved. I might just point out in passing that of the supervisors intended to transfer to the Bank of England, whatever date that is in the future, which we already identified, 76% of them, 3/4 of them, did not hold supervisory posts, relevant supervisory posts at the time, back in the summer. We changed 3/4 of the supervisory staff. So I'm not in any way trying to defend the approach taken to supervision in that period. To your specific question, I have to say, and I'm sure you will find it somewhat strange to hear, but it's true, that the FSA under the previous executive management operated in a very siloed manner, and we did not discuss specific major supervisory issues in our executive committee, and we were not encouraged to question or debate the management approach across the silos, across the areas. So to answer your specific question, there was no discussion. The Chief Executive the then Chief Executive did not convene any discussion on the merits of the deal.
I must say I find that absolutely astounding.
Right, I agree with you.
And I'm grateful for your frankness on this issue. Was there any discussion, as far as you're aware, amongst the members of the board of the FSA?
As to the best of my knowledge, there was not. I mean, I think the existence of the takeover was reported by the then managing director responsible for it, but you would not describe there being any substantive discussion at the board level. I should perhaps, in fairness to the people involved, indicate that as though there was no discussion in the executive committee, I understand from those who prepared the report that there were some bilateral conversations between the chief executive and the relevant managing director, which I was not party to. So I should be a little careful as to the degree of discussion, but there was no formal consideration of it in the executive committee or the board.
I mean, a very large chunk of the Royal Bank's business fell under your remit as managing director of...
if I may interrupt, that's completely untrue.
Could you tell me how much you did?
None.
None at all?
None at all.
So no part of the RBS at all?
No part. I have no involvement whatsoever, in any way whatsoever, in the supervision of RBS. The way that the chief executive, the then chief executive, had organised the FSA was to place those institutions of the which were domestically located in the United Kingdom inside one division, and in the other was placed the markets activities, i.e. overseeing stock exchanges and so forth, and overseeing wholesale foreign institutions, and it was a integrated, holistic approach. So the investment banking division of RBS was regulated and overseen by those people who looked at the rest of RBS, all of which sat within the responsibility of Managing Director Retail. I had no involvement whatsoever. I had no knowledge of what those supervisors were doing. There was no cross-discussion in the FSA. At no point in my tenure did I ever discuss RBS.
You are painting a picture of a wildly dysfunctional organisation. Can I just ask you then, so as I understand it, therefore, the investment banking part of the business was treated under the retail side, and therefore you had no visibility to that at all?
Correct.
Was this a position that you complained about?
Yes.
Did you push for some ability to have oversight into the RBS at that time?
I did, but the offer was not taken up. It probably does fall into the categories of things where if you look back on it, maybe I should have shouted louder, but I did raise the question with the then Chief Executive.
You sound like the Governor of the Bank of England. Sounds
well,
like
I was conscious of that when I said it. But, you know,
Okay.
I'm sure you appreciate I've gone back over these events many times in my mind to see if they could have been done differently, and given what happened, it would be nice if I could point to some document where I laid out all the risks of that. I can't, but I can tell you in all honesty I did raise the issue.
This really then, I will close, is a question for Lord Turner. Obviously you were on the board of the FSA at the time, am I right about that?
No, I joined the board of the FSA on September the 20th, 2008.
2008, okay. So when you came in, this was already an organisation that had been in some transition?
Yes.
By the time you arrived?
Yeah.
And you've made certain further proposals to this committee for the board of the FSA to be improved in various different ways, or as it were, scouted them. Do you think similar concerns could be expressed and addressed through improvements to the Court of the Bank of England in terms of its own supervisory arrangements? Since, as you may know, we've been very critical of its inability to act as a genuine board of supervision.
Well, I think, can I just start as a background of saying that the FSA board, like the FSA, does a very wide span of things, too many. And one of the things that has made me a strong supporter of what is now intended is a realisation that just the sheer span from the prudential regulation of major banks to the conduct regulation of IFAs is just too much to do and produces a diversion of approach. Secondly, I think in terms of the way that the FSA board operates and reports, we will be heading in the future in three different directions. One of which is the FCA board, which I think should probably be more open about the debates it has on things like the RDR and the mortgage market review, illustrating to a greater extent than we do at the moment the arguments put for and against. Because often there isn't sensitive supervisory information. There are public policy debates. There is another bit which will head to the PRA, which is the supervisory stuff. It is always quite difficult to be open and accountable on any current basis about the discussion on actual prudential supervisory cases because they are of their nature highly confidential. I mean, we are having detailed conversations, as you would understand now, about the Eurozone, which it would not be reasonable to put into the public domain. The third category, which we should have been doing, but weren't doing much at all, was the, as it were, macro-prudential, how is the whole of the system operating? Now that in future will be really the responsibility of the Financial Policy Committee, and there I think the Shadow Financial Policy Committee has already started with a high degree of openness as to the debates that are going on there. So there is an ability, looking at there...
I make a different point, which is what we are seeing today is a description of an utterly dysfunctional board of the FSA. The FSA the board is allowing this institution to do these things that Mr. Sants describes it eloquently, and failing to intervene and failing to organise or to make sure that the result in part is a catastrophe. The question is, with that much dysfunctionality, is there a danger of replicating this absence of proper scrutiny in institutions such as the Bank of England?
Well, I don't think so. I mean, because I am on the court of the Bank of England, I was a party to the document on bank accountability, which I know this committee had some concerns about. But I think it was a reasonable set of suggestions, and I felt, if I may, that you may have not appreciated the way that could develop. I mean, what that document was saying was that an oversight committee could exist, which would produce an annual report on process. We have in the Monetary Policy Committee and the Financial
We're not
Policy
here
Committee.
to discuss this.
Well,
let's make this. I know the question was asked. So
the question was
let's
asked.
Have a quick,
I'm very
let's
happy
have a quick
to
go and get back to the report we're discussing.
Okay. The question is on the Court of the Bank of England.
Let's have a quick go on it, and then.
Oh, you want a quick go? Okay. In the substance of its activity, there is a high degree of openness of its nature within the Bank of England on the Monetary Policy Committee. I mean, we can see the debates going on there. There is a high degree of openness now on the Financial Policy Committee, and that's appropriate. What is proposed is an oversight committee which would produce an annual report, and to my mind this isn't simply 2 paragraphs in the general annual report. It would be a serious annual report of the oversight committee which would be seeking to ensure that you were satisfied that there was no groupthink going on, that the individuals who had counterpoints of view were able to put them forward, that the processes of analysis had been driven by the external members as much as the internal members. I think that would help ensure process. And then there is also a proposal in there that where there has been a set of developments which are controversial, a trusted external body such as the IMF would be asked to give a report on substance. So that, for instance, if one went through a period...
We've read the report, so...
Well, my point of view is that it could be made to work. It depends on the details.
We may take further evidence on that in due course. Pat McFadden.
Mr Sants, can I take you back to the judgments the FSA made about the ABN AMRO takeover? In autumn 2007, you did consider the question of whether the FSA should intervene in the takeover, and you concluded that from a capital perspective, RBS would be able to deal with it. Given that this was the deal that ended up sinking the bank, wasn't that a disastrous misjudgment?
I'm going to first of all just make clear, I do think when you read the press there can be some misunderstandings on this point, that at no point in the process at all was the FSA required to approve the acquisition. So there was no formal requirement to sign off or to in any way approve it. There was no specific decision.
To intervene, did you not?
If I come on, there was no specific decision point. I decided to, and I might point out that the previous chief executive had not, that it would be a good idea, a proper idea, to assess the risks in the transaction, which I and the chairman did do so a number of times in late September, early October. But you need to be quite clear at that point. Once the offer document was published, which it was on the 20th of July, the only basis under which we could have intervened would be if we had concluded that the bank, on completion of the transaction, would not meet threshold conditions. I'm absolutely clear, and again, I've been over this in my mind a number of times, I remain completely clear there was no regulatory basis for an intervention. So no, on the information available at that time, it was not possible to intervene at that point after the offer document was published. So I did not have the power to intervene.
Do you regret the judgment that you made about the capital strength of RBS being able to handle that deal?
I think you misunderstand what we were doing. We were not making a judgment. We were assessing whether the bank met threshold conditions. That is a very specific test that requires us to conclude that the bank will imminently fail, with near complete certainty. The bank did not fail for over a year. It did not fail until there was a significant deterioration in market conditions, which occurred from the summer of 2008 onwards, and until after Lehman Brothers collapsed, which dramatically changed the liquidity framework for the marketplace as a whole. You could not have concluded it did not meet threshold conditions in September 2007. So you can go back over that judgment. I have been back over that decision many, many times, but the facts remain the facts. There was no basis to intervene.
But aren't you really saying you're just guilty of the same misjudgment as the RBS board, in that you thought that they would be able to handle this?
No, it wasn't a judgment in the way you're describing it. It was not a judgment about the future. It was a decision on whether it met threshold conditions. In order for it not to meet threshold conditions, you would have had to be able to say it would fail. It did not fail immediately the acquisition took place. Therefore, the events demonstrate that was the only conclusion you could reach. We're talking about the board making judgments about risks which might or might not have happened and saying they took an unreasonable degree of risk. That is not the same as assessing the test of threshold conditions. The time for the FSA to have intervened, as the report clearly says, was before the offer document was published. And I entirely agree, as we did to the earlier discussion, that they should have made an assessment of risk at that point. And I would like to think if we had done so, we would have intervened. I can't say whether we would or we would not, because that's obviously a hypothetical question, but I would like to think we would have done as the report says. But this is not the same as what as the board was doing. This is a regulatory conclusion based on a set of facts. The RBS was meeting its regulatory capital at the time of the deal. It was going to meet its regulatory capital immediately after the deal closed, which it did. It was funding itself in the marketplace. It in fact was telling us that it was benefiting from a flight to capital. It had succeeded, despite the fact, I accept, that it had essentially a cash offer, in finding funding for its cash offer. A regulator could not have warranted an intervention. If a regulator had intervened at that point, people would have said, you can't do that. It's totally irresponsible. It is not in any way linked to the powers that you have. What we would like, which is back to the earlier questioning in terms of different powers, is a different sort of power. A power to actually make the judgment that you are saying I should have made, which is there is a reasonable risk that it will fail, therefore it can't go ahead. That is the power we would like. If we'd had that power, back to the earlier question, you could then hold the PRA to account in the future as to whether it successfully makes those sort of judgments. But the threshold condition test is an entirely different sort of test. I'm afraid I think it's really important you understand that. It's in no way analogous to the judgments the board of the RBS are making. But we would like a power. We're prepared to take on that responsibility, which no doubt will produce some very difficult decisions in the future, which you rightly will then wish to hold us accountable for.
Let me take you through what you did on capital over the next few months, because the FSA started to get much more concerned about capital and liquidity issues at the end of 2007, beginning of 2008. You met with the Chief Executive of RBS in April 2008 to discuss the bank's capital position. You asked for further work on this to get the definitive position. We understand that work wasn't done. Why was that?
You're right. In practice, it didn't make any difference to the outcome, because the reason I asked for further work was they had indicated to us that their capital might have fallen by some 0.1% below our internal guidelines, which is a very, very small amount, but nevertheless an issue of concern that triggered a debate with us. I had the conversation with the Chief Executive on the 9th of April, and I specifically required him, which is in the record, related in the report, to have a rights issue, which he certainly, as far as I could judge from that meeting, was not intending to when he came into the meeting with me. And I asked him to raise as much capital as he possibly could. I also asked him at that point to complete that capital calculation and return that information to the supervisors. Unfortunately, RBS's systems did not allow them to do that, and I have to say that is a criticism of RBS. But in terms of the outcome, in terms of future events, it didn't make any material difference, because we require them to raise as much capital as possible. They have a rights issue, which I think was one of the largest in European corporate history, and certainly in the UK banking sector. And they did everything they possibly could to bolster their capital position at that point, but of course in the light of events proved not to be enough. So you're absolutely right, they didn't comply with our request to give us the detailed information. Does reflect the very poor state of their systems and controls, which throughout this period was a major issue. Their systems and controls were extremely poor, as the report demonstrates.
At the end of 2007, you put them on a watch list for capital risk. We put a danger sign over RBS. They then increased dividend payments 2 months later by 10%. Can you tell us, did you have any power to press the pause button or stop that increase in dividend payments after putting them on a capital watch list?
No, I mean we would have been. We would, in order for us to intervene on the dividend, they would have to be non-compliant with our regulatory rules. When they raised their final dividend, actually they raised the final dividend by 4%. I think not 10%. It was the total dividend for the year, but the final was up 4%. We were not required to give approval for that increase, and they were still complying with their capital and liquidity rules at that point. But we were not required to give a formal approval to that dividend increase. We were notified the day before, but there was no dialogue on that dividend issue.
Can I just ask you one final thing? There was 13 months between the run on Northern Rock and the collapse of RBS. And these issues were at the top of the national agenda. We then find that there was no contingency plan throughout that period for a bank that couldn't meet its overnight funding, despite the fact that RBS and one or two others were hugely dependent on that kind of funding. Looking back on that 13-month period, don't you think the FSA was asleep at the wheel?
There was a contingency plan, so I don't recognise that statement. We should recognise, as the report says, if there is no liquidity in the market, a bank is not going to be able to find liquidity in the market. Therefore, for banks of this size, the contingency plan is provisioned by the central authorities, by the central bank. And as the documentation makes clear, from the end of November onwards, which is when, as you rightly point out, the FSA became concerned about the potential capital and liquidity risks for the larger banks, we were pressing from that point onwards, as I think I've mentioned in earlier Treasury Select Committee hearings, for the Bank of England to put in place long-term liquidity facilities. And the chairman of the FSA, Callum McCarthy, was very active in that dialogue. So we were seeking to put in place the appropriate contingency plan for liquidity failure of a bank of the size of RBS. The FSA does not itself have any liquidity that it can provide. When marketplace liquidity disappears, the contingency plan has to be one for the central bank, and we were clear about that from the moment that we saw a deterioration in the liquidity position of the larger banks, which we saw from the end of November, and we put that in writing to the tripartite authorities repeatedly from then on.
Doesn't your report at paragraph 550 say, is this not a quote from it, that there was no FSA contingency plan in the event that a particular bank can't fund its overnight
No,
position?
what that just says is that there was a director in the FSA who was not party to the tripartite and senior discussions, which I referred to, sent me an email asking whether there was one. That doesn't mean there was one. There wasn't one. It just means that he was not party to the tripartite discussions, in particular the discussions between the chairman, the governor, and the Treasury and the Chancellor.
So he was wrong.
He was asking me a question, which I answered, yes, there is a contingency plan.
Can I just take you back, Mr. Sants, to this question of the what you described as the poor systems and controls in RBS that prevented them from doing the work on the capital position that you requested of the Chief Executive in April 2008.
Yep.
What does it say about the FSA's systems and controls that you demanded it but didn't get it and didn't follow up on it?
Well, I think it says that we were extremely stretched during this period. Maybe I'll come back a little bit to the opening discussion we had.
All very
with
busy,
Deputy Norman.
and therefore
should have. If I could finish the question, I'm entirely agreeing that the quality and quantity of the supervisory staff that I inherited in the summer of 2007, as well as the procedures and philosophy they were operating to, was inadequate.
It does sound
and that is why we have changed. And we started with, as you know, some 7 people on RBS. We currently, as a dedicated supervisory team, have 23. On major issues such as stress testing, we use between 50 and 100. We were notified, as you say, that there was uncertainty over the March year-end return. But first of all, I'd like to say even efficient banks don't necessarily know the absolute final number within a couple of days. Secondly, the difference was only between, say, 0.1% on 9. And thirdly, once we had requested them to have as large a rights issue as possible, our focus was on maximising their capital position. Would it have been better if the supervisory team had followed up to close that out? Yes, so I do note the report finally notes that actually RBS believes they may not have breached the ICG. But actually it made no substantial difference to the outcome here. As a general point, are you saying, yes, the FSA was understaffed and lacked enough quality staff to address the enormity of the crisis which broke from October onwards? Absolutely, and that's why we have added some 600 more supervisors, changed the way we operate, changed 3/4 of the staff, and adopted an entirely new model. So, it was working in a very stretched environment.
Okay, but Mr. Sants, I'm not asking you whether it made a difference that they didn't follow it up. I'm asking what it told us about the FSA at the time. That
it told us that it was very stretched and needed to focus on the essentials, and this was not an essential point. This was an unimportant point in the context of trying to ensure RBS did not fail.
Can I take you back to some questions that you answered about your role as head of wholesale?
Mm-hmm.
During your time as head of wholesale, the investment side, the side which plausibly would fall under wholesale, was growing very fast, wasn't it?
Sorry, the investment side. Oh, the investment bank of RBS, yes. Between 2005 and 2007, there is statistics in the report.
Yes, which I've got in front of me here, growing very fast and was best part of 2/3 of the bank's capital base by 2007. You've said that you raised this. Have you any evidence at all that you raised it?
I did not raise the specific issue of the growth of the investment banking
but
side.
You raised your concern.
The concern I raised
about the silos.
Yes, the concern I raised was, which was highlighted to me by my staff on the investment banking side that looked at Morgan Stanley, Goldman Sachs and others, that they had considerable expertise in investment banking activities, and they were not able to share their expertise easily with the supervisors in the UK Banks Department.
The question is,
I'm afraid I do not have anything in writing that can demonstrate that. You have to decide.
None at all.
No, I mean I can ask other individuals in the FSA whether they're happy to corroborate that. I can think of one or two who might well be, and if you'd like me to do that, I can certainly do that.
You were on the executive committee at the time. An executive committee will have minutes. Didn't it cross your mind that you should at least get your reservations, bearing in mind the gravity of the situation, into those minutes?
I think
you said you were very upset.
I think that's a fair point, and I did not read it into the executive committee minutes. Actually, I have to say the executive committee minutes of the FSA are action point minutes. They are not actually.
Well, you wanted some action taken, didn't you?
Yes, I agree. I acknowledge
so they were
that
exactly
point.
What you'd expect.
I'm acknowledging that point. If, with hindsight, I should have ensured that it was fully documented that I expressed my views. But I also expressed my views about the limitations of the management in that area, and actually I think Margaret Cole did the same, so she may wish to corroborate the general concerns we had about the weak management in the retail area of the FSA.
But this is something that you felt was wrong at the time, raised in the corridors or privately or informally. Do you remember how you did this?
I raised it in a number of in my regular meetings with John Tyner. We also raised the question of the general quality of management in that area informally in the margins of a number of the executive meetings.
And what did Mr. Tyner do when you mentioned this term?
He made it clear that the model he had set up for the FSA was of autonomous business units, and that was how he envisaged it being run. On the question of the individual...
So he was saying it's none of your business, really? Let the retail side go.
I think he took the view that he had... Well, it would be for you to ask him, but I think he took the view that he had set up an autonomous business model arrangement and that was the way he wanted it run. But as I say, I might invite Margaret to join in because she was part of the executive committee. You are asking for some corroboration, and she could...
I don't think there's any need, because it's your replies that matter on that point, since it was you that was head of...
Yes, and I could also point out at this point that I did ask for the resignation of the Managing Director of Retail, which I hope demonstrates my views on that subject.
When did you do that?
As soon as I reasonably could, which was after the completion of the Northern Rock report.
Andrea Leadsom.
Thank you, Chairman. Ms Cole, I'd just like to ask you, as a legal person at the FSA, I certainly recall John Tyner talking very much about principles-based regulation and not about sort of very narrow definitions. And Mr Sants says that it would not have been possible, once the offer document had come out, for him to do anything other than to shut it down if the bank, if the merged bank was absolutely imminently then going to go bankrupt. Would you say that that's true from a legal perspective at the time of that report coming out, and bearing in mind the FSA supposedly was working under principles-based regulation?
I'd say that it was certainly true. The legal advice that was given to Hector on that subject was given by General Counsel's Division, so not by me, but I do endorse the fact that there were very, very strict legal requirements for the test of not meeting threshold conditions. So I do have to say that I don't think the principles, which are a set of principles that govern the behaviour of firms and individuals within firms, which you quite rightly say overarch the detailed rules, I just have to say I don't think the principles were operationally relevant to that particular decision. There was a very strict legal test for that.
So you agree that it would not have been possible for Mr Sants coming in as the new CEO to have been able to stop that deal going ahead at that point on any grounds other than it being imminently about to be bankrupt?
I agree with Hector's explanation about how we had to consider whether threshold conditions were met, and that was the pertinent and relevant test at that time, and that principles were not applicable to this.
It just, I have to say, it does seem to me astonishing that somebody who is earning more than five times the Prime Minister of Britain actually can only express a view if it is going to be the imminent collapse of a bank, where clearly you had very grave concerns. Were there no other hook or by crook measures you could have used to make clear your concerns about this merger?
I'm not earning 5 times the Prime Minister. I have no final salary pension or defined benefit pension, but that's sort of by the by, but it's not correct what you just said. I think, I would make the point here, we are unelected officials, and as I've said many times before, I believe it's important that we work within the rules set by Parliament, the law. We should operate within the law. The general principle that still prevails, and was certainly prevailing at that point, was that boards take responsibility for running their own firms, and that ultimately the decisions for running firms well rest with the boards and their executives. And that for the FSA to act as shadow directors and second guess the judgments that executives and boards have made was absolutely not the philosophy prevailing at the time. To have intervened in a bid which had been nearly unanimously, 95% approved by the shareholders, which would have required the triggering of the MAC clause by the firm to pull out of, unless we had the power to do it. It does not seem to me that I should be seeking to intervene in a way that I was not mandated so to do.
No,
I think
Mr.
you would
Sants,
consider that a misuse of my position if I had merely just sought to disrupt the deal in an irresponsible fashion.
Yes, but Mr Sants, even the Governor of the Bank of England found a way to talk publicly about the need to sort out our deficits during the period in the run-up to the general election and got into trouble for that, but he found a way to get his view known. What we're talking about here is the extent to which you really were genuinely concerned and felt completely unable, and you were legally unable to act and reflect your concerns, versus you were just going along with it because you were caught up in the sort of herd mentality of the RBS board and the shareholders.
Well, I certainly wasn't caught up in the herd mentality. I draw your attention to the point earlier that the previous Chief Executive had not even thought that he should consider the issue. I mean, surely the issue should have been considered was before the offer document. I had the guts to consider the issue. I actually did what nobody else, including my executive chairman, with whom the final decision ultimately rests, not me, to get out there and take a look at the question.
But you didn't act in any way other than to say, you know, it's not going to imminently go bankrupt.
It's not actually for me to act. I could just repeat that. We do actually have a system here. There is an executive chairman of the FSA. If I had sought to act capriciously or unreasonably, I'm absolutely sure the board and the chairman would have told me I could not do that. I think your line of questioning is implying this is a decision solely for me. It was not a decision solely for me. There is clearly the fact that it is executive chairman of the FSA who was party to the deliberations. But nevertheless, I would like to restate, yes, I did look at it responsibly, and I concluded within my powers I could not act. I consider that to be, I was doing my utmost to address a very difficult situation.
So then, in conclusion, from everything I've heard, you're utterly blameless, innocent. There's nothing you could have done differently or better, and you have no regrets about anything of your part in this whole fiasco. I mean, there's nothing that you feel you could have done differently.
Look, I'm answering the very specific, narrow question of could we have done something different after the offer document was published in relation to the ABN AMRO deal. And I'm saying I've been over that many, many times in my mind. And the answer is no. Does that mean there are other things I could have done differently? Absolutely. We've referred to a number already.
Thank you.
Michael Fallon.
Well, let's just have a look at the timeline again. You took over in the end of July 2007. In Appendix 2C, the timeline tells us that you had 3 assessments of the impact of this acquisition, 19th of September, 28th of September and 4th of October. This is 2 months after you took over. But it then took another 4.5 months before you even met the chairman of RBS, which was then by far the biggest bank you were dealing with. Why was there a 4-month delay?
Because in that period, up until the end of November, we were extremely focused on the risk posed to the mortgage banks of the United Kingdom. Northern Rock initially, HBOS, Bradford Bingley and Alliance and Leicester. They were clearly the most at risk institutions. I think the Northern Rock report has already indicated we are aware of that from the onset of the crisis in August, that these 4 institutions were at risk. We had almost no investment banking expertise in the FSA. We had very limited risk analysis expertise in the FSA. We had a very small number of supervisors, as I say, 6 or so on RBS and 1 to 2 on these other banks. And I thought it was the best use of my resources to concentrate on those institutions most at risk. Would it have been ideal if I had also spent some time with RBS in that period? No doubt. But I think you underestimate the stretch that was placed on the organisation, and I made the judgment, which I think is a reasonable one, to deploy my resources where we had institutions most at risk. As we indicated earlier, RBS was complying with its capital and liquidity guidelines throughout September, October. It was actually benefiting on the liquidity side from a flight to quality at the end of September and early October. And the risks to the larger banks in the United Kingdom did not become apparent to us until the end of November, early December, which was the time it was placed on the watch list. So I think the answer to the question is I can't be everywhere at once. We had a very, very small number of competent professionals. I think you underestimate the strain and the stress under which the organisation was being put at that time.
Yeah, but I'm not really talking about the organisation or your resources or anything. We're talking here about you.
Yes, well, I've told you what I was doing. I was addressing the principal risks facing the United Kingdom financial sector at that time, which was the risks to those banks I have outlined, and that is where I put my personal effort. We had a supervisory team, and they were on the case of RBS in that period, but they were making the judgment, which they were advising me on, that it was not materially at risk until the November period.
Yes, but it wasn't until the 13th of February that you're going to meet the chairman of your biggest bank, the one they've said might be at risk. Why was that delay?
I've answered the
October,
question
November?
because at that time I judged that my time was best used addressing the near and present danger to the other institutions, and that was what I was doing.
Do you now regret not seeing the chairman or chief executive of RBS a little bit earlier?
I think it would have been better, certainly would look better for this discussion if I had done so, and that falls into the category of a number of procedural issues that I think it would be, with hindsight, I could have done differently. But it doesn't alter, I think, may make a general point about all the actions that took place between November 07 and September, October 08. At the end of the day, we realised that RBS was short of capital. It was us, it was me personally, in a meeting with Fred Goodwin, that pressed him to have a rights issue. I have no doubt that he would not have had a rights issue of that size without my personal intervention. He raised as much capital, or the firm raised as much capital as it possibly could. There is no evidence, if we had intervened earlier, that they would have raised any more capital if they'd had the rights issue in November or December. At the end of the day, the largest rights issue in the UK financial sector proved not to be enough. Whether that rights issue had occurred in November or whether it occurred in April would not have made any difference to the bank failing. Similarly, on the liquidity point, it went into the summer of 07 structurally deficient on liquidity, as the graphs point out. There was no way that it was going to be able to alter that liquidity profile given the market conditions from November onwards. So the nuances of what we did one day by that day doesn't alter the substance of the point that we pushed them throughout to improve their liquidity position. We engaged with the central bank to put in place contingency facilities. We pressed them to raise as much capital as we possibly could. It would not have made any difference when they raised that capital, and the amount of capital they raised was not sufficient to stop them failing.
You still don't think it's odd? It was a 4-month delay.
I'm saying it would have been preferable for the purposes of dealing with this discussion
chairman.
if I had seen the RBS chairman. But I do remind you again that it was the tradition in the FSA at that time that the chairman of the FSA engaged with the chairman of banks. I actually was the first chief executive to get interested in having regular dialogues at the senior executive level. I now have regular meetings every month with the chief executives of the major banks. I think, again, that's a question you could partially address to the former chairman of the FSA.
You keep trying to offload the blame. If you were changing
No,
the
I'm not
culture,
offloading. I've taken
why did it take 6 months for you to meet the chairman?
I have answered the question with hindsight. It would have been better if I had.
I see.
I've said that once. I've said it twice.
Okay. Now, in the report it says at 446 that once the crisis period started, there was limited action that the FSA could take to improve the firm's liquidity position, given market conditions.
Yep.
When, for the purpose of that sentence, did the crisis period start?
Well, as I've indicated, from November onwards, it was apparent that the RBS and the major banks were under some liquidity pressure. As the graphs, which I think we've got a time of in here on, you bear with me, the liquidity graph on page 197, paragraph 471, however, demonstrates there wasn't any, the material deterioration in the liquidity of RBS began to occur in July 08 and then accelerated obviously after the Lehman Brothers incident, and as the report makes clear to that effect. But there was pressure, as I indicated earlier, on the major banks from November onwards, which is when we were pressing the authorities to put in place their contingency planning.
But there were liquidity issues brought to the fore by the mortgage bank issues back in October, November 07. Why would it take another year for some action to be taken?
I said November 07 we were pressing the central authorities to put in contingency, and the assessment that I received from the supervisors in September, October, on which we based our threshold condition conclusion, made very clear that RBS was not actually suffering liquidity pressure at that time. In fact, quite the contrary. The supervisory group advised me that the firm had made very clear to it that in that period it was benefiting from a flight to quality and was actually gaining deposits because of the pressure on the smaller banks in the period described. So in September, October, there were no signs of increased liquidity pressure on the major banks as reported to me by the supervisory group. And I think the report found no evidence that report was inaccurate. But from November onwards, we did have concerns. And as I said, that was the point at which the chairman of the FSA started pressing the central bank and Treasury to put in place contingency facilities. That's November 07. That's from the end of November 07.
But it was then still a further year before RBS disintegrated.
Yes, so the point of the paragraph you drew attention to was we shouldn't think that the firm was not aware that it had a wholesale liquidity risk. It was very apparent it had a wholesale liquidity risk. It was seeking to improve its position in the marketplace, but was not able to do so. So there is a difference between conditions under which you can improve your liquidity profile and conditions under which your liquidity profile is deteriorating. And I'm explaining that the conditions that prevailed, as that paragraph, I didn't write that paragraph, it's an independent report, so again we could maybe ask Adair to comment here, but the report is highlighting that the ability of the bank to improve its position was not there. But that does not mean that the bank's position was deteriorating, and it did not markedly deteriorate, as that graph shows, until July. But as I say, I think you should be aware these are conclusions of the report. I didn't write the report.
But we're testing this conclusion. The conclusion is there was limited action that either you or the bank itself could have taken.
Yes, but that's not my conclusion. That's
the
conclusion of the independent report. I'm suggesting that the chairman might like to...
What we need to test is whether it's right.
Well, in my judgment,
there was limited action that you could have taken over a period as much as a year to improve the firm's liquidity position.
Correct, and I believe that judgment of the report, the independent report, to be correct.
Thank you.
Mark Garnier.
Thank you, Mr. Chairman. Hector Sants, you're painting a pretty staggering picture of sort of institutional incompetence at the FSA in the time in the run-up when you took over. You've also told us at great length how you were trying to raise the issues, the fact that you thought there were a number of things that were not right about the organisational structure of the FSA. Who were you raising that to?
Well, I think I've covered those points earlier. I acknowledge that we did not raise them formally, and with hindsight, I wish I had done.
I want to know who didn't take the action.
Oh, well, I raised them with the Chief Executive.
Chief Executive. And would he have referred that back to the board?
I can't tell.
Should he have referred it back to the board?
Well, it's an interesting question, that, and again, I might like to comment, but historically, and I think there is some material there in the report on the board's role, historically, in general, the board primarily restricted itself to its policy role of rulemaking and took relatively little interest in the supervisory model. So in my view, there was very little challenge by the board of the executive of the way we went about supervision, which was clearly, in my view, a failing of the board, which has since been rectified. And in bringing in the new programme, Supervisory Enhancement Programme, the board rigorously engaged with the executive team as to the nature of that model and whether that model would address the shortcomings of the past. But traditionally, no, the board didn't engage with the executive on these sort of issues.
I mean, in Lord Turner's 2009 review, he identified 7 causes to the financial crisis. Were any of those discussed at board level that you know of prior to the financial crisis? Would you like me to remind you what they are?
You might be nice to do so.
So I'll go through them one by one.
I'm sure Lord Turner can remember.
The massive growth and increasing complexity of the securitised credit model. Was that discussed?
Not to my knowledge.
Extensive commercial bank involvement in trading activities.
Not in the way that report describes.
High leverage in multiple forms.
No.
Expanded maturity transformation dependent on the marketability of assets. No. Complexity and opacity of the structured credit and derivative system.
There was some discussion on that, I think, but I have to say we'd have to sort of double check the minutes. But I think
not enough.
Yeah.
Hardwired pro-cyclicality.
Yeah, so there was some discussion of that because that would have fallen into the category of discussing rulemaking, and obviously the board did approve the Basel II rules, and therefore where you have policy issues which manifest themselves in regulatory rules, then the board engage with those topics. But to your general point, just to wrap it up as a clean answer to avoid us having to come back in detail, you're entirely right that the FSA did not give any consideration to financial stability in any material way or the risk in the system as a whole. So, of course, to be fair to the board, there was no specific and clear mandate so to do. And indeed, the MOU says that was the responsibility of the Bank of England.
If I can just quote from paragraph 691, because we did look through the board minutes, it is noticeable that during the period between January 2006 and July 2007, of the major topics discussed at the FSA board, only 1 out of 61 related in some way to bank prudential risks and issues. And
so 1 out of 61?
1 out of 61. The focus was very strongly on equitable life, split capital trusts, RDR, treating customers fairly, etc. That was the skew of the focus of the board at that time, against the background of a widely held assumption, but in retrospect complete delusion, that the world had become a safer place precisely because of all these complicated things, which in retrospect we know had made it less safe.
But in the report, the FSA puts a great deal of emphasis on the performance of non-executive directors of RBS, and yet the non-executive directors of the FSA were sorely lacking in really scrutinising what was going on. And there is a suggestion that there is a conflict of interest between having people with sort of direct industry experience on the board of the FSA, and yet it's absolutely because of the lack of that direct industry experience that you managed to hardwire pro-cyclicality and other things into the system and only examine 1 out of 61 problems that were identified.
Well, can I comment? I think it goes back to the comment I made earlier. It's my belief that the FSA was set up as a job to do far too wide a span, and I have been continually aware of that at board meetings over the last few years, that we have enormously long agendas and enormously long meetings. We have to go in detail through mortgage market review, retail distribution review. We now go through in great detail what is going on, particularly in the reports from the CEO and from Andrew Bailey now, the director in charge of bank supervision. We go through in very considerable detail the risks and how we're addressing them. But at the time, that was squeezed out by other elements of the agenda. And I think it reflects the fact that that was not an intelligent way to set the system up, and that in the future we will have dedicated people on the Financial Policy Committee who will simply be focused very extensively on the macro-prudential, on the overall systemic risks. And we will have people on the Prudential Regulatory Authority, both in respect to its executive and its board, who are simply focused on the supervision of major banks. I think it is too much to expect somebody to be dealing with these incredibly complicated issues of capital and liquidity if you're also asking them half of their time to be expressing a point of view on key data or arch crew or retail distribution review or mortgage market review. It's too wide a span of control.
And just if I can add briefly with regard to the PRA and looking forward, there's some recommendations from David Walker, which I entirely agree. It's vitally important that the independence of the PRA board, I think, do come with current industry experience. I recognise the point about conflict, and we'll have to think through how do we avoid conflict, particularly if we want to involve the board, the independent board members, as we do, in individual supervisory decision making, so they would be part of the assessments of these sort of important questions we've been talking about today. But I think basically we do have to have current experience involved with the independence on the regulatory boards. But as Adair says, that's an argument in particular for specialisation, because the wide span of the FSA set of responsibilities clearly proved too much for the board to be able to effectively oversee, and I agree with the points you're making.
Well, certainly, on a number of occasions, you've made the point that the board should have quite detailed minutes coming out in order to make each individual member more accountable and to sort of air their views a bit more enthusiastically. And yet, and I haven't read it in detail, but I understand that the Financial Regulation Bill actually doesn't, with regard to the FCA, doesn't make any requirement that the FCA publishes minutes and merely leaves it up to them to decide what they should or shouldn't do. Do you think that's a mistake in the bill?
I wouldn't be against it being put into the bill. I think the FCA board may well, and I will recommend, that it thinks very carefully in future about the style of minutes. I mean, what has struck me is that on the Monetary Policy Committee side and the Financial Policy Committee side, we have a style where you see the people who are responsible for making the ultimate decision expressing alternative points of view. And you have a minute that says some people said this, some people said that, they considered this data, at the end of the day they concluded X. We have not previously provided that openness in relation to, for instance, the debates about the RDR. So we have not been transparent as to whether there was a variety of points of view, what factors were considered. And I can't see a problem with doing that, and indeed I think that as we move to a new structure and think about it, that would be my recommendation, that we do have that degree of explicitness, because I think it's very important when you look at an issue like the RDR or the mortgage market review, that people understand that these are not technical decisions where there's one necessarily right answer. They are a balance of different points of view, and that those different points of view and how it was resolved should be open. Indeed, I would also suggest, and I think I recommended this when we talked before you on the issue of the FCA government, that you have never previously asked non-executive directors of the FSA to come towards before you in the way that you ask the external members of the MPC and the FPC to. And I think in future, where we have major retail conduct policy issues like MMR or RDR, that would be a perfectly legitimate thing for you to do.
My very final question, Hector Sants, in the light of everything you said to us a bit earlier about the fact that you were raising these issues, do you feel that having published minutes of boards would give an opportunity for people such as yourself in your previous position to be able to wear those concerns publicly, or at least to get them down on the record, so that should the person who's sorting out the next crisis, which I hope doesn't happen under your watch, but should it do, then they'll have an opportunity, rather than to rely on good friends to come up and fly your flag, that there would actually be minutes recording that.
Yes, but I sincerely hope the next crisis isn't on my watch. But yes, I am broadly in favour of public minutes and entirely endorse Andrea's general sentiment.
Fantastic, thank you.
Jesse Norman wanted to come back to the point. Very quick question. Mr. Sants, you said that having an early rights issue in November 07 would have made no difference versus when it actually took place in 08. I wonder if that can be true, because, of course, there was a raised dividend in between, and if RBS had done a rights issue, they would hardly have raised their dividend.
But that is possibly true. But the amount of the raised dividend, I think from memory, is about £210 million. Is the difference between the 1 penny extra. Their final went from 22 odd p to 23p. I don't think, sadly, that 210 million would have made any difference to the outcome for RBS.
When Michael Fallon asked you about funding for the building society market, you responded by saying that RBS had benefited by getting deposits. But wasn't it true that the failure of the building societies was pointing to a drastic shortfall in money market wholesale funding, on which RBS was itself extremely reliant?
At that stage, on the supervisory information I was given, there was no evidence of that. In fact, my recollection is that the general comment about flight to quality, which the firm made to us, covered both wholesale and retail.
Could I just take you to paragraph 433 just to clarify one point? It says, while the FSA senior management, this is September and October when you were in charge, was concerned, while the FSA senior management was concerned by liquidity conditions in the markets at that time, the scenario under which those risks could crystallise for RBS was considered very unlikely. Did you agree with that judgment?
Well, that was the judgment that the supervisory assessment paper presented to us.
Yes, but are you the chief
did I
executive?
agree with it?
So I'm
yes,
asking
I did
agreed
not
with
anticipate. I mean, I fully acknowledge, people were asking earlier, when I look back on events, what do I think about them? And I absolutely acknowledge I did not envisage Lehman Brothers failing in the way that it did, and I did not envisage the catastrophic collapse in market conditions and confidence that occurred in late
tightening, weren't they, by that time?
Well, I come back to the point earlier, which we've just touched on. The supervisory team clearly stated, and the firm was clearly stating to them, that they were a beneficiary of these tightened markets. And that did not seem to me to be an unreasonable scenario whereby major global institutions would be a gainer from pressure primarily on smaller institutions dependent on the securitization funding model. I entirely agree that events that transpired, that the FSA was not envisaging the events that transpired in the autumn of 2008.
Can I just take you further on to paragraph 435, where it seems that adequate attention was not paid to the information that might have been available from the Dutch Central Bank, the DNB. Were you aware of this at the time?
I was not aware of that detail. That was the responsibility of the supervisory team.
Well, it's a bit more than a detail, isn't it? This is just to clarify, just to clarify, Mr. Sants, this is far more than detail. This is going to the central bank of the bank, which is about to be taken over in the biggest banking deal in history, to find out whether they've got anything to say that you think you ought to know. So it's not a detail.
No, absolutely. And I said I was not in receipt of the detail. I'm sorry if I was clumsy in my wording. I was in receipt of the general feedback from the DNB, and I do indeed have memorandums with that material on it. And the DNB were not giving us any material risk warnings at that time. And I believe this paragraph actually says that the DNB did not communicate significant risks to us.
Well, what they said was that they were relying on you, isn't it? The DNB informed the review team it believed the FSA would supplement the answers provided by RBS.
That was in regard to RBS. I assume what you're discussing was the DNB's information with regard to ABN, and as I'm saying, they did not highlight to us any major risks in relation to ABN. What they said to us, however, which was perfectly reasonable, they were relying on us for the analysis of the risk in RBS, which was perfectly reasonable.
Could I also just take you to paragraph 439, which is, I suppose one could say, the exoneration paragraph, where it says, in the context of the time, the decision by the FSA CEO and chairman not to intervene, that's you, in the period after the offer had been published was reasonable. The paragraph then continues, given the low probability of extreme liquidity stresses emerging, that's the point we've just discussed, and then it says, and the FSA CEO's and chairman's judgment that the intervention could itself have destabilised RBS. So you were taking into account the risk that if you intervened, you yourself could create a financial contagion. Is that right?
Not exactly, no. I think that sentence could be runs misinterpretation. I think there are two different issues, and I did try to draw that out in the earlier discussion. I'm perhaps maybe just return to that. So there was a clean judgment of threshold conditions, or a clean decision on threshold conditions, which we covered. And as I say, I've been back over that many times, as Margaret has said. We remain clear there was no regulatory basis for an intervention. So we could not have intervened. But even if we didn't think we had any grounds for intervention, it did cross my mind a little bit to some of the earlier questions that maybe I should just be saying, this is an irresponsible deal, you shouldn't be doing it, and making some public pronouncements, or maybe even trying to intervene, at which point the firm would have pushed back and said you can't do it, but maybe that whole furore would in itself have been a useful intervention. And I concluded, and I think David Walker in his remarks to you agreed with me on that point, that being just disruptive was irresponsible and could in itself have destabilised RBS. The board might well have responded very negatively to that. So that's a slightly different point to the straight judgment on threshold conditions.
So just to get back to clarity on this point, you're saying you couldn't intervene?
Correct.
whatever happened, you couldn't intervene. What
On-
you could
on
have
the
done
information
is, what you could have done
available
is
at the
smash
time.
the furniture, but you couldn't intervene.
Yes.
That's correct?
Yes.
Okay. Andy Love.
Lord Turner, before you published this report, it went through the Maxwellisation process. There's been lots and lots of speculation in the newspapers, and indeed Sir David Walker, when he came to speak to us last week in a session, confirmed that there were changes made to the report. Can you detail for us the changes that were made during that process?
Well, I can absolutely confirm that there were no changes which made a material change to the overall thrust of the report. It is part of the agreed process that reports of this nature should go through a process to which the name of Mr. Maxwell is forever connected, Maxwellisation, where they have the right to look at it and make comments on it. And those comments, as you will probably understand, are voluminous, and they often contest lots of different points, and they contest them as being unreasonable or not supported. We then had to go through and see whether there were any of those that we thought were legitimate. And as we went through, and this was a process very carefully with myself and Sir David Walker and Bill Knight, there were a small number where we said, yes, look, on reflection, we don't really have a strong support for that point. And indeed, I have to say that one of the things that Bill brought to the process as a lawyer was a very strong focus that we should only put in reports things for which we had an evidential base, and that if you didn't have an evidential base for it, we would be detracting from the quality of the report by putting stuff in that wasn't there. In relation to the specific one that Bill Knight mentioned, I draw your attention to paragraph 612 of the report on page 234, where it sets out 4 questions. And it says, we asked 4 questions about Goodwin's capability and style. Those are whether his management style may have discouraged robust and effective challenge from the board and senior management teams, whether the levels of remuneration paid to RBS executive directors, i.e. those that reporting to him, may have played any part in discouraging robust and effective challenge to the CEO, whether the CEO was overly focused on revenue and profit targets himself because of the way he'd been incentivised, and whether his response to the emerging losses, and I consider this a very important one, in structured credit, monoline insurance, etc., was reflected a bias to optimism. In the earlier version of this, we had a 5th question, which Bill Knight referred to, whether he had a focus in his own experience towards retail banking rather than to investment banking. That was a 5th question, posed as a question, not a fact, which was in an earlier version. When we went through it, and I think you can take it that every one of these was challenged, we thought that that was the only one where we were not convinced that it was highly material or clearly evidence that that was relevant to the story, and therefore we changed that.
Well, and that's a very detailed response, but what I want to focus on is the claim that originally the description was made in the report about the ABN AMRO takeover as being a risky gamble. Can you confirm or deny that those words were used and changed? And if they were changed, what do you think is an adequate description of what went on in terms of the takeover?
I think we still have the word gamble in there somewhere, if I remember rightly. I'm afraid I haven't memorised it, but the word gamble is in there. I think, if I can be honest, and it's a bit of telling stories, I think we had a slight difference between our 2 external reviewers in their appetite for whether the word gamble was absolutely the best word to use or not, and we debated it, but the word gamble is put in there. I think it was a gamble, actually, in the sense of it was a...
Would you accept a risky gamble?
Oh, it was undoubtedly a risky gamble, but I think all gambles are risky. I mean, aren't they?
Just to...
Well, the chairman's not sure, in which case I want him to tell me these non-risky gambles, because I'll start wagering on them.
Carry on then.
Have you... because I think what is coming through to me at this stage is that there was an acceptance in the FSA at the time of this takeover that while there was no grounds under current conditions, and we've gone into this in some detail, to intervene, there was a very strong feeling that this was, and I use the words that Mr. Sants used earlier on, an irresponsible deal was the word, and you've used other similar phrases. Is that, in your view, Mr. Sants, adequately reflected in this report? I want to ask Mr. Sants, because he, as I understand it, he didn't have anything to do with this report, but it reports on many things.
Yes, well, I think you used the word risky and a gamble. As I say, unfortunately, I don't immediately have it at hand, but I think it is in there, but certainly risky, highly risky. Thank you very much. It's consistent with the wording I've used, and as you rightly say, I think it is reasonable to conclude that it was a highly risky transaction, and events showed it to be.
But can I just clarify? I think what this report shows is that, sadly, prior to the point at which this offer had already gone out and been given a 95% vote by the shareholders on August the 10th, there was not adequate focus within the FSA that this was a highly risky thing to do. As you go through the months of April, May, June, July 2007, we are not finding evidence of anybody in the FSA at that time saying this is a highly risky gamble, we better try and stop it. And there was not and that is what the report says, that there was a failure to recognise that the sheer scale and nature of this thing should have provoked a change to the classic non-interventionist way of the FSA dealing with a major acquisition. So I think there was a failure to understand or to focus on, or to consider that it was part of the role of the FSA to focus on the risks involved in this acquisition.
And certainly when we have deals now notified to us in advance, we have now demonstrated, we have a visible track record of intervening in a very early stage before offer documents are published to minimise the risk, or even at times sometimes to try to dissuade management from acting. In those cases it won't have been visible to the marketplace at all. And that approach is one that we now take as part of the new proactive supervisory approach, and I entirely agree with Adair. That was lacking. The report is clear that it was lacking. I entirely agree it was lacking in the FSA's approach in the past. But
was that a lot, Turner, highlighted? I mean, there's plenty in this report, and I'm talking here now about getting the proper balance. There's plenty in here of criticism of RBS and its management, and indeed there's been even more this afternoon. But did you balance that against the responsibilities of the FSA? You're now highlighting the fact that there were shortcomings, and indeed Mr. Sants has gone into this in some detail about the shortcomings. Do you think the report gives a balanced position in relation to responsibilities vis-à-vis RBS management and the FSA executive?
Well, I think it does, in particular in relation to this. If you look at paragraph 420, it says the FSA's supervisory approach to the acquisition of ABN AMRO did not entail adequate assessment of the risks which RBS was taking. This reflected that approval was not required, supervision lacked a defined approach, the prevailing philosophy and approach of the FSA believed you should leave these things to senior management. It says clearly this was a significant
Let me ask you a question that's been put to me. You have to get to page 342 of the report before Mr. Sants is mentioned. Now he was second in command, if I can call it that, because I can't just remember offhand his title when he first came to the FSA.
One of three managing directors.
One of three managing directors, and subsequently chief executive during part of this. Now, I think you would accept that it's not unreasonable for this committee, recognising that Mr. Sants will have a continuing very important role when the PRA is finally established, to question whether or not this report adequately ventilates the issues for which he was responsible. There are many who have commented that that isn't happening. What's your defence of ensuring that there's adequate reflection of the role of Mr. Sants since coming to the FSA?
I honestly think there is. I'm not sure about your reference of, did you say page 344? Because
page 342.
Well, there are lots of references. I'm just randomly looking on 182 to 183. He's not referred to as Hector Sants. He's referred to as the FSA CEO. But in that period, the FSA CEO is Hector Sants. So there are lots of references before that where he is named by title. And on the whole, and it was one of these sort of issues of style that we went for, we decided to go more for titles rather than names. That's a stylistic choice you made, but it's clear whom it refers to. So we have carefully considered, and the review team considered, and I considered, and the external reviewers considered, what exact words we should use, in particular, about the decision not to intervene in relation to ABN AMRO, and that's something that we gave very careful consideration to, what should be the exact balance of the words. My own belief is, I have to say, that if I had been there as chairman or chief executive at the time, I would have reached the same decision, which in retrospect, knowing what we know now, we all regret, but I feel that with the information available then and the legal powers available then, I would have ended up making the same decision. I think what we also describe in this is an organisation which from autumn 2007 onwards is beginning to get a grip on the faults that it previously has. It is leading the way with new liquidity standards, leading the way with new capital standards, doing the drains up on Northern Rock and putting in place a supervisory enhancement programme. Now, it is the nature of all of such things that if they had been put in place about 3 years beforehand, they might have helped prevent some aspects of the crisis. They were just of the nature that if you start there, you can't prevent the crisis that then occurs. But I do think that Hector led that transformation, and that is the judgment that I have made, that he has been the right person to lead the FSA and to stay on and lead the transition to the PRA.
I understand that, and this committee has gone through many sessions trying to understand all of the changes that you're talking about. But I think at the time when the new regulatory structure was introduced, Mr. Sants, along with many other people, commented that it's the quality of the staff that will be the final arbiter of how well you do as a regulator. And it's really to that question I want to put my final question to Mr. Sants. You've gone through a baptism of fire, if I may say so. What do you think you've learned that better equips you now for doing the job as PRA chief than perhaps you did when you first came to the FSA?
Well, 3 points on that, I think. First of all, I should say, you are asking me the question, I will answer it, but I do think the right people to ultimately answer that question are the people who make the appointment. But I realise you've asked me, so I will seek to address it. I think I'd like to make a couple of points. I think, whilst I do think, I genuinely believe, I accept this for others to judge, that in the period after I took over the FSA, during the crisis, that in the circumstances, given the whole legacy that we took into it, I do believe that the FSA did its utmost in that period. I'm not saying that at the end of the day, the outcomes were what we would have liked. Obviously, they were not. They're not what anybody would have liked. And the crisis has been a major crisis. But I genuinely believe in the round over that period, we did our utmost. And I'll be more than happy at any time to sit in front of this committee and go through in detail, in more detail than we've managed to do today, every decision we made. And I would like to think if you were faced with the information we were faced with at the time, with the resources we had at the time, that you would recognise we had done our utmost. But as to your specific question, it might be worth just reminding ourselves that I was leaving. I was asked to stay on. I decided that it was the right thing to do to stay on the basis that I accepted the argument made to me that I was the best person to take forward the regulatory reform programme and leave the regulatory regime in a good shape. And that is what I think I should be judged on. About judging people, the quality of people. I've been given a specific task which I decided to take on, I was persuaded to take on. That's what I'm currently delivering. I'd be more than happy to spend more time in this committee on whether I am delivering against that reform programme. At the moment, that reform programme is on track. I think we have learned a lot from the experiences, and we are using all that experience to make a better regime for the future, which will significantly diminish the probability of these types of crises happening again. And the final point is, when I look back over particularly those early months, and there's been much discussion about September, October, and could the judgment have been different, and could we have intervened earlier? But when you look around all that, I have absolutely looked around that whole process of decision making. I am sure, in the round, the authorities as a whole would have made better judgments if we'd had more people who had direct and immediate experience of a crisis of that nature, and we did not, for obvious reasons. And I think we are still in one of the most severe financial crises of modern times, and I think it's a very sensible judgment to be made by those who asked me and others to stay on, so that people could have the benefit of that searing learning experience. And I think, let us not underestimate, that was an extremely unpleasant time. I think everybody who knows me, I've been in front of this committee many, many times, will not have doubted that I've always acted with the best of intentions. I have 30 years of experience in investment banking. I've always done my very, very best. And I think that what I learned in that period, there is value in me imparting that to the system.
Mr. Sants, you've described several issues with your differences between you and your predecessor prior to taking the post in July. He announced he was going in January, I think. When did you find out that you were going to be taking over from him?
Well, again, I have to say it wasn't a job I particularly wanted to take on. I was persuaded to apply for the job. I can't recall precisely. I think it was in early July, pretty much around the time the press announcement was made. I'm afraid I can't recall the precise date, but it was in July.
Were you intending not to stay on?
Well, the original arrangement with John Tyner was that I would do 3 years as one of the 3 managing directors. He told me when I joined that he would be doing a longer period than he in event turned out to do. And I made it very clear that I had no interest in staying for that longer period to put myself forward for the chief executive post. So I didn't join the FSA with the intention of being the chief executive. I did not expect John Tyner to leave. I was not originally intending to apply for the job. I was persuaded so to do.
John Thurso.
Hey, can I just ask you one point of clarification? RBS was in the retail section, so you weren't covering it. Were all the British universal banks in retail?
Yes. So I had no responsibility for any of the UK banks. So it's not a sensible structure.
More than half the
just to remind you, I changed that structure as soon as I possibly could to a unified supervisory unit. If you are an integrated regulator, it makes no sense not to have a unified supervisory unit.
Okay, thank you.
Can I just throw one line?
Can I make one further point? I'll come back to you on that. You've on several occasions and in several answers prayed in aid what you did on the rights issue with RBS in getting it, pushing it through with Fred Goodwin. Can I just tell you that for quite a number of small investors, the Dowager Lady Thurso being one of them, the rights issue was not unalloyed joy. And what do you say to all the small shareholders who lost out as a result of that?
I'm truly sorry that the bank failed. We genuinely believed at the time, if we could raise capital of that type of magnitude, that unless there was a further dramatic deterioration in market conditions, that would be sufficient. Unfortunately, that proved not to be the case. But I am truly sorry for all the small shareholders who've been caught up in this financial crisis.
Can I come to you, Lord Turner? The question I wanted to ask is, there's 2 parts to this report. There's RBS and what they did, and frankly, I mean, it's not often that one reads reports of that nature and finds them as gripping as that one was. It sets out very clearly what went wrong, and I don't want to rehearse that bit. But the other strand in it is obviously how the then FSA reacted, and that's largely what we've been rehearsing today. And obviously we're looking at this with the benefit of 2020 hindsight. But there are many places in the report where the approaches and decisions of the FSA have been criticised, were even wrong with that hindsight. Do you think this was because of the culture in the FSA, or the structure of the FSA, or a combination of both?
I think it was a combination of the structure of the FSA and the entire intellectual philosophy of the time. As I've said, I think the structure of the FSA, the fact that it had been given responsibility for this enormous span from the capital and liquidity of major banking groups through to all the wholesale conduct issues in markets, but then also retail conduct. I think that was too wide a span. I think there is an intellectual affinity between thinking about the capital and liquidity of banks and central banking that makes that logically better reside within the central bank, and that there's a different set of disciplines to do with retail conduct, and that is why I believe that the future structure is better. So I think the structure was problematic. But even more importantly, the FSA had fallen, but it was not alone in this. Indeed, a lot of the cleverest economists and authorities in the world had ended up believing that the global financial system had got safer because of innovation, liquidity, ability to distribute risk. So we have to put ourselves back in a mindset where people had simply come to the belief that we were in some great moderation of low and stable inflation, and that a lot of these problems of the past had disappeared. And that, after all, was the completely overt Greenspan document, that there was a more efficient way to distribute risk. And as I quoted in my own Turner review, if you look at the April 2006 Global Financial Stability Report of the IMF, you will find an extraordinary statement which says that because of the development of CDS and structured credit and distribution and securitization, the world financial system has become safer and, quote, the likelihood of, I can't remember the exact quote, but the likelihood of commercial bank failure has declined. It's an extraordinary quote in retrospect. And that is reflective, I can just say one final thing, with on paragraph 691, as a result, why were these banks given to the retail side of the FSA? Because it was assumed that what we had to worry about them was whether they were treating customers fairly. And as a result of 229 items reported in the 18 months before July 2007 by the Managing Director of Retail Markets, of those 229 items reported in the board reports, only 5 related in any way to bank prudential issues. That was just the mindset of the time. It's extraordinary in retrospect, but that's the way it was.
It is quite extraordinary, as you rightly say, that we could have had such a collective failure of common sense across all the regulators. This report says a lot about the FSA. It says very little about the other two wings of the tripartite system. To what extent should this report have also covered what the bank did or didn't do and what the Treasury did or didn't do?
Well, I think it's quite interesting in the US to look at a thing like the Financial Crisis Investigation Inquiry Commission, I forget the precise word, the FCIC, which is a very large analysis looking at the totality of what has occurred. And we haven't had that in the UK, and you could argue that if we could all roll it back to 2009, we ought to have launched a Royal Commission which would have looked at absolutely everything, including, as it were, each of the banks that failed altogether, rather than one by one, and at the role of all three authorities. And I think there could be merit in that at some stage.
I'll take that as you saying, yes, somebody ought to have a look at them at some point. Can I end with a question, Hector, to you, which is really to ask a fairly direct question that follows on from the comments that Andy Love was making. And I think really only you can answer that. Do you think it's appropriate that account should be taken of your particular actions as set out in this report previously in making a proper assessment of your future in regulation?
Yes, entirely, but I come back to the comment I made earlier, that what I've undertaken to do is to deliver the regulatory reform agenda. I believe I'm doing that very effectively. I'm happy to debate that with you or answer questions on it, and when I've completed that, I shall be have completed the job I've committed to do.
Better the repentant sinner than the untried evangelist. Thank you.
Lord Turner, has the production of this report improved the quality of the work that the FSA does, or prejudiced it?
Well, the process of the report itself, or going forward, the lessons learned from it. But
I'm talking about whether producing this report has meant that people working in the FSA are likely to be more alert to the dangers
I understand
than they were before you produced this report.
I think this has been...
And to perform better than they would
Yes,
otherwise
I think this
have
has
done,
been...
Or has it prejudiced their performance? I'm asking the question in a new way.
I think it is favourable. I mean, if we go back to what are the lessons learned from this report, many of them we knew already. I mean, the basic fact that the capital and liquidity regimes were, to be blunt, rubbish, we knew already and we were putting right. The supervisory approach was wrong and it was putting right. I think what we have here, and I have, when we produced this, I strongly urged all staff members, particularly those going to the PRA, to read it. I think we have got something here which all prudential supervisors, at least for the next 10 years, ought to read as part of their training programme. Indeed, I actually think all non-executive directors of banks ought to read it, because I think when you have a lengthy and I believe high-quality report of what went wrong, there are a lot of lessons that you can get out of it, and they just tell you what is the story of a bank that makes a collection of mistakes that leads to failure. That's very important for people to read.
Could I just add, because we've obviously had a robust exchange of views, I also do strongly believe in this report and this process as part of it. I strongly believe that the regulators should be accountable for what they've done and the actions they've taken, and they should be transparent and explain the basis and the thoughts behind what they did.
That's
so I
what
think
we've been trying to do.
Yeah, so I think the whole process is one we ought to
understand.
embed going forward, and I hope the PRA, to some of the earlier points, is at the forefront of being willing to...
Well, we're engaged
to
in trying
basis.
to improve the transparency and the accountability of these bodies, as you know, in a couple of reports we've produced recently. Michael Fallon.
Are we going to, Lord Turner, get an equivalent report on the failure of HBOS?
Well, as I wrote to the chairman sometime in early July, it is our opinion that we should produce a report, or somebody should produce a report on HBOS. In timing terms, we have, as we did with RBS, the complication that we are, it is publicly known, we have an enforcement process in place, and until that is concluded, which of course can be some time if it was to conclude that there was a case and that somebody then appealed, it could get delayed. Until that is produced, we cannot produce the report. What we have, however, done, we have put in place a small data gathering team. They will not write down anything which is a judgment, because we can't do that without potentially prejudicing the enforcement process, but we are going through the process of gathering together the files, doing some of the straightforward a calculation analysis that we did with RBS on capital and liquidity, having done it before, so that as and when we get to beyond the enforcement case, but I do stress we have no control over the overall timescale of that, we will be in a position to launch it. Now, I think at that stage, there are a set of pros and cons, and they were touched on by David Walker in front of you, as to whether one does that with an external review process or internal. One of the problems, on the whole, I think this process has been incredibly successful. I think the combination of an internal process with external reviewers has produced a high-quality report. It is very time-consuming for a lot of our best people. It's time-consuming at a senior level. It's been very time-consuming myself. So there's a bit of me thinks that the best thing would be simply to pay somebody else to do it at that stage. But there are very strong pros and cons of that, which relate to the wider issue going forward for the PRA as to whether reviews should be externally done. But in summary, I believe that we should produce something on HBOS which is equivalent to this. The good news is it should be shorter because it is a more simple business. It's not it wasn't in lots of different businesses in the way that RBS was.
It's over 3 years since HBOS failed. If we're going to get a report like this, shouldn't we have it fairly soon?
Well, we are in a legal position where we cannot, without prejudicing the enforcement case, launch a separate public accountability. Now, within the bill, there are, I think, quite appropriately, and again, this is something which I flagged in various letters to the chairman,
and which I've raised with you as well,
which
privately.
are issues as to who, and I think it can only be the Treasury, should be the arbiter of whether one thinks that the publication, there's such a strong publication interest that we should be willing to prejudice an enforcement approach. But I think it would be unreasonable for us to do that, because if that resulted in a prejudicing of an enforcement case, we would then be criticised. And that's why we've welcomed the idea that going forward, there is somebody who is responsible for making that balance in the timetable.
Thank you very much, all three of you, for coming this afternoon. It's been quite a lengthy hearing, quite important for transparency, and very much along the lines of the sentiments that were being expressed a moment ago by Mr. Sants. We're very grateful to you, and we've got a lot to digest now, and that's what we'll do. Thank you very much indeed.
Thank you.